us, sir.
Sure. So even though, Lydia, on its face, this is a victory for the plaintiffs, even though the jury found Meta and the other defendants negligent, that is, they failed to comply, excuse me, with a reasonable standard of care, they failed to take account that they were producing a product that was addictive to children. I must tell you, the $3 million number here is so low. It is less than what Meta offered to settle the case for before it went to a jury. So in that respect, Mark Zuckerberg and company are very happy. However, in respect of the first finding here that they were negligent, they're not happy. Remember, this case is what we call a bellwether case. It was the case that the hundreds of plaintiffs' lawyers out there agreed they would watch and use as a standard. And if the defendants were found negligent, the other cases would be settled. But I must tell you, the number is so low here.
What was that number again? I wasn't aware the number came out. What was the number?
$3 million. The number is so low.
That is low, yeah.
It is. Look at what the plaintiff in New Mexico got yesterday. It was 100 times that number,
almost 400 million.
$375 million. So the number is so low that this is either going to do one or two things. There either will be another bellwether case, probably also in Los Angeles, or Zuckerberg and company will start writing small checks to all these 2,000 plaintiffs that are out there waiting for their cases to come to court.
Wow, so the jury awarding $3 million in damages. And to your point, this is the first consolidated group of cases brought against the company. We're talking about 1,600 plaintiffs, including over 350 families and 250 school districts. Judge, nonetheless, Meta found liable. Does that set a precedent, even though there's such a low number here? Perhaps could they not prove damages here, but nonetheless they were able to prove liability?
Yes. The short answer, it's a great question, Lydia, and the short answer is yes to both part of your questions. This does set a precedent, particularly in light of it following the decision in New Mexico yesterday. So if you put New Mexico and Los Angeles together, it's not a good day for big tech. It is clear that average jurors listening to evidence were convinced that big tech does not protect children. That's the headline. However, the damage to this plaintiff and the award to this plaintiff is so low that I'm sure Mark Zuckerberg is smiling.
Now, the New Mexico case had to do with online predators. This had more to do with addiction. So do you think that explains why we see such a disparity, almost 400 million, 370 plus million in damages for the New Mexico case, and this LA one, 3 million?
You know, in this case, Lydia, it was really what we call a swearing match between experts. So the plaintiffs had psychiatrists who said the girl is injured. The defendants who had psychiatrists who said, yes, the girl is injured, but it's because of a poor upbringing. It had nothing to do with using Facebook. The plaintiffs had experts saying, look at all the mistakes that they made. Look at all the things they did wrong when they're crafting their software. The defendants' experts said, look at all the things we did right. The jury took all of that into account and decided that, yes, they were negligent, but they didn't really cause that much harm. So I suggest to you that we will see more of these cases going to juries before we see a flood of settled cases. You mentioned this earlier, Lydia. There are 2,000 cases out there. These are plaintiffs from all across American society. I don't think they will be happy with this low number, and I think some of their lawyers will be willing, as we say, to roll the dice, to go before a jury, to go through the time and expense of a jury trial, and see how the jury ends up.
All right, Judge Napolitano, Senior Judicial Analyst for Newsmax. Sir, thank you so much for joining us. Thank you.
You're welcome, my friend.
Thank you. All right, we'll be right back. Don't go anywhere.